You welcome everybody back to House General Housing. It's Friday, April 25th, and it's about a little after 1 o'clock. We have 4 witnesses that we are going to have. We're going to start with our alleged counsel, Sophie Zdatny, and I think Terry will be here. Joe McNeil, Chris Hoare will testify. And we're taking testimony on S-125, which is an act relating to workers' compensation, which that part of it we're not hearing, but collective bargaining issues and rights. So, Sophie.
Good afternoon, Sophie Zdatny for the Office of Legislative Counsel, and I'm just passing out Section 941 of Title III. This is under the State Employees Labor Relations Act. I think this is going to seem really familiar, and I think you had additional explanation this morning from the witnesses around how this works, but I just thought it might be helpful to run quickly through the statute because it's not necessarily intuitive, and I think every time someone testifies, it gets a little bit more confusing and maybe not quite as clear. So not a reflection on any of the witnesses, just it's confusing stuff. So I just thought it might be helpful to go through the process. So this is really the process for determining a unit. So this would be for starting a unit for an employer, the certification process, and it also includes decertification. So subsection A, again, you've heard this already, but the board is the one that makes the decisions around unit determination, certification, and representation. So they're going to decide who's in the unit, they're going to certify the unit and decide who the representative organization is going to be. And then on subsection B, no bargaining unit or collective bargaining representative shall be recognized by the employer until the board has determined the appropriate unit to be represented and has formally certified its determination. I will say there are other labor relations statutes not involving state employees where an employer can voluntarily recognize a unit, but here you have to have the board, to recognize the unit. So C1 gets into the process for filing a petition. So again, to file a petition, to seek to organize and to be represented by a unit, by a representative organization, you need to have not less than 30% of the employees. So again, signatures on cards. You need to have 30% of the proposed unit that you're looking to organize. 30% of the people that could be in that unit need to sign something, and that's then going to get submitted to the Labor Relations Board. And then in the middle of that paragraph, it notes or that the individual or employee organization currently certified as the bargaining agent is no longer supported by at least 51% of the employees in the bargaining unit, or they're now included in an improved bargaining unit and wish to form a separate bargaining unit under board criteria. So this is the decertification language currently. So you need the 30% of what's called showing of interest, that you either want to decertify the current union and have no union, or if there's another union that wants to come in and represent those employees, again, you need that 30% of recognition. I'm just going to highlight the language that says by at least 51% of the employees, because there was a question yesterday around why does this say 51%? So this is not saying you need 51%. It's just saying that on the petition, the showing of interest is that you've got signatures from 30% of the people saying that they believe there's 51% of the employees that no longer support the current bargaining unit. So essentially a majority.
I am having trouble with this language, I confess.
So, I mean, any of the elections,
I understood, but the language is bothering me.
Well,
let's go take it a little more slowly.
Okay.
I'm looking at this paragraph C1.
Yeah.
Okay. So filing cards, filing a petition that they wish to form a bargaining unit, that's formation, right?
Right.
Okay, and that's not less than 30%.
Right. And it's the same threshold.
Or can be represented, or that the individual or employee organization currently certified is no longer supported by at least 51% of the employees.
So this is just,
The sentence says they have to file a petition saying that
right,
the employee organization is not, oh, they're asserting in their petition
right.
that it isn't. So, but it's 30% for either one. What a sentence. Okay. Good Lord. All right. So in other words, if I want to start a union or start a bargaining unit, I file a petition that says I'd like to start a bargaining.
But with the signatures, right? You can't just as an individual say,
No, I can, but I have to have 31. I could file a petition and there have to be, but if I was writing the petition and that I was going to copy and give to everybody, I would write a petition that said, we wish to form a bargaining unit.
right. And that,
Okay.
and that you believe there's support for a, for a bargaining unit.
Well, it doesn't say that.
Well, I think that's what
Yeah, it has form a bargaining unit. That's what they're
all.
signing
They're
on
30
to.
that they wish to form a bargaining unit.
Right, and then,
Period. But if I want to, according to this sentence, excuse me for harping on the sentence. My God, if they want to decertify, and I was writing the petition out, I would have to write on the petition that I want to decertify the union, and I believe that they are not supported by 50%
Right.
plus one
That
of
does
us.
read
well, it
that
says
way.
51, yeah. at
Yes,
least
I have to
51.
put it on the petition. Right, okay, wow, all right. Okay, I'm with you so far.
Okay. So 2A at the bottom, towards the bottom of the page, that is, again, this is getting into determining the appropriateness of the unit. So, and there are timelines in here. I'm not going to go through all the timelines, but essentially the employer has the opportunity to raise any questions about the appropriateness of the proposed bargaining unit and raise any other unit determination issues. So again, depending on the size of the employer, the issues are going to vary, but essentially the employer can say, we don't think this is an appropriate unit. You shouldn't have these folks in it. Or if you're going to do this, you should have these other folks in it. So this is the stage at which the employer can raise issues. And then as we turn over the page, so a hearing shall be held, but I just want to jump ahead a little bit because under subsection Roman 3 at the top, the board may endeavor to informally mediate any dispute. So again, you've already heard testimony to that effect, but generally what happens is the petition comes in, the board looks at it, the employer says, I don't know, I've got questions about this. The board is trying to informally resolve those, get the two parties to agree and sort of work out what the answer is going to be. And then if there's an issue, that's further down, but if there's an issue, then they'll do a hearing. So the employer files with the board and with the employees a list of all the employees that could potentially be in this unit and the job titles. There's been conversation before around, it's not Joe Smith that's going to be in the union. It's, Joe Smith's position as, a clerk or whatever the case may be. So again, this is information that's needed in order to determine who should be in and who should be out of the unit.
Both the employer files a list and the employees who are moving this thing.
Yeah, I mean, and again, maybe that some of the union representatives can provide more testimony in terms of exactly how that works. But my understanding is that either the employees or the organization that's looking to represent the employees is going to have a sense of how many people they think should be in the unit, and that's going to be the number that. And I will say that typically, although it's the 30% to show interest, if you're an organization, if you're a union looking to organize people, your goal is going to be to get as many signatures as you can. 30% is just the minimum. You're going to try to get 60% or whatever. You're going to try and get as many signatures as you can when you file that petition. The 30% is just the threshold that you have to meet. And again, so once you get to this point, then the employer and the employees through the board are going to go through everybody and would they be in this unit? Does their job title qualify them to be in the proposed bargaining unit? The list is kept confidential. It can't be shared under Public Records Act. If you're decertifying,
Question.
Can I just ask a question on that? That's because in decertification, there's no card check option, correct?
right, right.
So in certification, if we're going with the 50% plus one,
We're going to get to that further down in this.
it is not kept secret and you can look at the employees.
So when you have a bargaining unit that's being created,
Yeah,
both sides, I mean, you're all working from a common list.
yeah,
When you're looking to decertify, you kind of know who's, it's you know who's in the unit.
okay,
So,
thank you.
right. So the board, a board member or a person or persons designated by the board, then investigates the petition. So again, this is just looking to see, is there a sufficient showing of interest? Do they have the, signatures from the right people? If there's a question that exists, there's reasonable cause to believe that a question of unit determination or representation exists, then a board hearing is scheduled. And again, I'm not going to go through the next couple of sections here, but just so you know that there's a board hearing, they have rules around the hearing. If the board finds that there isn't enough evidence to support, moving forward, then they dismiss the petition. So at the top of the next page, E1. So once you've established that you've got the substantial interest, you've got the showing, then you move forward with the secret ballot election. And then again, there are deadlines around this. We had mentioned that before, but the board prioritizes these petitions. So they sort of jump to the front of the line because they have very tight timelines associated with it. And then an election is held.
So this paragraph E1 is only about formation.
No, this would apply for
It
decertification.
says interest among employees in forming a bargaining unit.
Right, but this is the same process.
Yeah, but it says what it says.
Does.
It says this applies to forming a bargaining unit. Is it really that badly written?
But I would say in the statute's defense that it was initially written in 1969 and it's been amended many times since then. And it's, if one was starting from scratch today, would you write it this way? Probably not. Right.
All right.
But the English language hasn't changed since 1969.
It says, whenever on the basis of filing a petition under D1, and D1 presumably refers back to B, which in turn was about either one. Okay.
Right.
Oh, yeah. Okay. What it means, you're telling us, if the board finds substantial interest among employees in forming a bargaining unit or in decertifying it.
Right. And then they're going to move forward with an election. And then the election is conducted. And there's, again, I don't know how much you need to know on this, but if you're forming a unit, then there's sort of very specific questions that are asked. If you're decertifying, again, it's going to depend on what the situation is, whether it's just a question of, do you want Union A to continue to represent you? But again, if there's Union B that wants to come in and represent, you may be asked, the ballot may have a number of options on it for decertification. So anyway, the board determines the secret ballot election shall be conducted. Again, a lot of this, depends on the mechanism. You could have an in-person election, you could have an election by mail. If you're talking about a plant, and all the employees are in one place, then you might have a in-person voting and you make sure it covers all the shifts. If you're dealing with a workforce that's spread out across the whole state, then doing a mail-in election probably makes more sense because there are too many different locations where people work. The list, I don't know that we need to go through all of that. At the bottom of page, whatever we're on, 3, the board can extend timelines. But again, the goal here is to move these forwards as expeditiously as possible. Top of page 4, section F. And we've talked about this in the past, but in determining the appropriateness of a collective bargaining unit, the board takes into consideration the following, but this isn't an exclusive list. So it says, consider the following, but it's not limited to these criteria. But one is the authority of government officials at the unit level to take positive action on matters subject to negotiation. So again, that's making sure that the people that would be at the bargaining table have the authority to negotiate for that particular group of employees. Two, the similarity or divergence of the interests, needs, and general conditions of employment of the employees to be represented. So essentially, that's the community of interest inquiry. And again, it may be that the board determines, actually that this should really be two separate units. They can, that's when you would make that determination whether the folks that are looking to organize, again, share a community of interest with each other. And then three is whether over-fragmentation of units among state employees will result from certification to agree that's likely to produce an adverse effect either on effective representation of state employees generally or upon the efficient operation of state government. Typically, that's the goal is to avoid having a multitude of very tiny little bargaining units. But so you've got to weigh those, particularly those two things between community of interest and over-fragmentation. You don't want to be so specific on the community of interest that you've then got these very fragmented bargaining units. So subsection G talks about the secret ballot election. And again, the last line of that, no representative will be certified with less than a majority of the votes cast by employees in the bargaining unit. So it's a majority of the votes cast. It's not a majority of all the people that could potentially be in the unit. But it is a majority, which effectively is the 50% plus one. Subsection G2, if none of the choices, and again, this would be true again for a decertification provision, if none of the choices receive a majority of the votes, then you do a runoff election with just the top two from the first round.
I have to ask this. Since on the prior page, E1 applies to both formation and decertification, even though it doesn't say that. Does this paragraph apply to both formation and decertification?
Yeah.
Even though it doesn't say it?
Yep. And again, you could have somebody intervene. So even with a brand new unit, you could have another union say, oh, actually, we'd like to represent them. So again, you can have choices. So you may need to have a runoff election, and then the board certifies the results. And then the new language, this is the language that came in with Act 117 at last session, is at the bottom of page 4. So it's G4A. This is the majority sign up or card check.
Okay, we're going to break for a few minutes. There's a strange odor. The fire department's coming in to investigate it. And so we're going to stop business. Do you want us to stay here?
You can stay, I know you videotaping, so.